Lady, I don't care what you think you're doing here. Turn around and use the public entrance. Officer Terrence Mack is standing at the staff security checkpoint of the United States Federal Courthouse on Pershing Avenue, one hand already raised, palm out, blocking the corridor. The woman he is speaking to is carrying a leather briefcase, wearing a tailored charcoal suit, and has just presented her Federal Judiciary ID badge to the scanner the way she has presented it every single morning for 11 years. The scanner beeped green. He stepped in front of it anyway. I said, "Turn around." She does not turn around. She stands with both feet planted, briefcase at her side, and looks at him with the expression of a person who has been here before. Not at this checkpoint, not with this officer, but here, in this particular gravity, in this particular version of the same conversation she has been having since she was 17 years old. "Officer," she says, and her voice is flat and even, "my badge just cleared. My name is on the judiciary staff roster. I need to pass through." Mack leans forward. "Your badge might clear. That doesn't mean you belong back here. I don't recognize you. I've worked in this building for 11 years. Then you know the rules. Public entrance is on the south side. Keep it moving." He gestures, a short sideways sweep of his hand, the kind you use to shoo something. People are watching. Two clerks near the copy room door have gone very still. A young paralegal with a coffee cup stands 3 feet away and does not move. A federal marshal coming off the elevator stops when he hears the tone of the exchange, looks, and very deliberately looks back at his phone. She sets her briefcase down, both hands visible. Everything measured. She has spent 31 years measuring things this precisely. "I would like your badge number." Mack straightens. "You want my badge number. You file a complaint at the public desk on the south side." He smiles when he says it. "After you use the public entrance." He has no idea. He has absolutely no idea. Because the black woman he just turned away from the staff entrance, the one he told to use the public door, in front of witnesses, in the building where she works, is the Honorable Vivienne Ruth Carver, United States Federal District Judge, appointed by the President of the United States, confirmed by the Senate, and currently presiding over the federal civil rights trial of Officer Terrence Mack. His trial. The one that starts in 38 minutes. But this story doesn't start here. Vivienne Ruth Carver was born in Birmingham, Alabama, the only child of Otis and Meredith Carver. Otis Carver drove a municipal bus for the city of Birmingham for 33 years. He drove the same route. He knew the names of his regulars and remembered their stops, and when a passenger was having a bad morning, he gave them an extra few seconds at the door without being asked. He was a man of reliable habits and reliable kindness, and the people on his route knew it. He retired on a Thursday, a small ceremony in the break room, a sheet cake, a card signed by 40 people, and was dead by the following Sunday. A heart attack, quick and without warning, in the kitchen of the house he had paid off in full the year before. He was 61 years old. Vivienne was in her first year of law school. She drove home in a car with over 200,000 miles on it and sat with her mother in that kitchen for 4 days before she drove back. She did not miss a class. Otis would not have wanted her to. Meredith Carver had worked as a seamstress for a dry cleaning establishment for 22 years. She altered suits and dresses and hemmed trousers for people who never learned her name. On the wall of her workroom, she kept a small framed photograph, not a family photo, not a religious image, but a photograph of Thurgood Marshall, cut from a magazine, taped to a piece of cardboard and framed in a 10-cent frame from the dollar store. When Vivienne was 8 years old, she asked her mother who that was. Meredith said, "That's the man who proved that the law can be made to mean what it says." She said it the way you say something you need a child to memorize. Vivienne memorized it. In her chambers on the 4th floor of the Pershing Avenue Federal Courthouse, on the shelf to the left of her desk, there is a framed photograph. Not her law school graduation. Not her judicial investiture. It is a photograph of Otis Carver standing in front of his bus, in his uniform, on a Tuesday in 1987. One arm on the door, head slightly tilted, looking at the camera with an expression that carries 20 years of early mornings and an unbroken belief that the work was worth doing. She has looked at it every morning for 11 years. She looks at it before she puts on her robe. She attended Spelman College on a full academic scholarship, graduated summa cum laude in political science, and enrolled at Howard University School of Law, where she served as editor of the Law Review and graduated first in her class. She clerked for a circuit court judge for 2 years, practiced civil rights law at a firm in Atlanta for 7, and was nominated to the federal bench at age 42, the youngest black woman appointed to a federal district judgeship in her circuit's history. She has presided over 1,847 cases in 11 years. She has been reversed on appeal 4 times. Her opinions have been cited by the Supreme Court on 3 separate occasions. On the morning of the incident, she had been visiting her mother in Birmingham for the weekend. Meredith is 81 now, still in the same house, still with the same photograph on the workroom wall, and had caught a 6 a.m. flight back in order to be at the courthouse in time to review her notes before the morning's opening. She was carrying the briefcase she has carried for 9 years, a battered dark leather case with a buckle clasp and her initials pressed near the handle. A gift from her clerks on her 5th anniversary on the bench. She had her coffee from the airport. She had her notes. She was just going to work. Her courtroom is on the 4th floor of the building she was just told to enter from the south side. On the ID badge that cleared the green light, her name is printed in full Hun. Vivienne R. Carver, U.S. District Judge. Terrence Mack has been a courthouse security officer for 6 years. His file includes 2 prior complaints about conduct at the staff checkpoint. One from a public defender who described being asked to prove her bar card was current, and one from a court reporter who described being told she didn't look like she worked there. Both complaints were reviewed by Gary Felton and closed as insufficient to establish policy violation. His personnel review from the prior year described him as reliable, consistent, and a strong presence at entry points. He had been given additional responsibilities twice. He considered himself excellent at reading situations. He was not reading this one correctly. 31 minutes. In the lobby outside courtroom 4C, Assistant U.S. Attorney Donna Osei was reviewing her notes for the morning's opening argument when her phone buzzed. The text was from a paralegal named Marcus, who worked on the floor below. It read, "Judge Carver is at the North Checkpoint. Mac won't let her through. I have it on my phone." Dana read it twice. She stood up. She walked to the elevator. On the North Corridor, the situation had not resolved itself. Judge Carver had not moved. She had also not escalated. She was standing exactly where she had stopped, briefcase at her side, watching Terrence Mack with the patience of someone who has decided that this moment will be fully documented before it is over. The paralegal with the coffee cup had her phone out now, angled down, not obviously filming, but filming. The 2 clerks had not gone back to work. Mack was certain he had this right. That certainty, unexamined, institutional, the same certainty he brought to every checkpoint call he had made in 6 years, was the most important thing about him in that moment. He looked at the woman in front of him, and he saw what he had decided to see. And he did not look further. He told himself he was doing his job. He believed it. That is what made him dangerous, and what would, in the end, make the consequences so complete. You cannot argue with a man who does not know he is wrong. He called his supervisor, a man named Gary Felton, who arrived 6 minutes later wearing a lanyard and a look of practiced authority, and immediately made things worse. He looked at the badge. He looked at the woman. He said, "Are you sure this is your credential? It lists a judge's chambers." "I am a judge," Judge Carver said. "I am the judge. I am presiding over a trial that begins in," she glanced at her watch, 26 minutes. Felton looked at Mac. Mac looked at Felton. Something passed between them that both of them would later describe very differently in their written statements. "Ma'am," Felton said, and the word landed like something he was using as a tool, "I'm going to need you to wait here while we verify. You have my badge number. The verification takes 40 seconds. We have a process." She looked at him. "I'm aware of the process. I've cleared that scanner every workday for 11 years. The green light is the process." Felton crossed his arms. He said they'd get it sorted out. He said it the way people say things when they have no intention of getting anything sorted out. When the goal is not resolution but compliance, not clarity but the specific satisfaction of watching someone wait who does not want to wait. She waited. 23 minutes. She waited. She set her briefcase down. She counted things. Not aloud, not visibly, but with the same methodical attention she brought to every case file on her desk. The kind of counting that turns an experience into a record. The federal marshal who had come off the elevator was named Supervisory Deputy Marshal Aaron Tillman. He had gone back to his phone, but he had not left the corridor. He was a careful man, and he had been in federal buildings long enough to know when something was wrong in a way that would matter later. He was now standing 15 feet away, facing slightly sideways, with his phone in his hand and the camera on. The text he sent at that moment went to the office of the chief judge of the district. 18 minutes. Donna Osei arrived at the north checkpoint and stopped. She looked at Judge Carver. She looked at Felton and Mac. She understood the entire situation in approximately 4 seconds. "Judge Carver," she said, and made sure her voice was loud enough for everyone in the corridor to hear, "The courtroom is ready for you." Felton turned. "Are you associated with this individual?" "I am associated with this courthouse," Dana said. "As is she. As is her courtroom, which opens in 17 minutes, for a trial that Officer Mack is a defendant in." She paused. The word defendant landed in the corridor and sat there. Someone should probably let him through. The silence that followed lasted about 3 seconds. Mack's face went through several things in those 3 seconds. Recognition arrived last. It arrived like something cold. He stepped aside. Judge Carver picked up her briefcase. She did not look at Mac as she passed him. She looked straight ahead, the way she always looked when she was about to walk into a room and begin. She did not hurry. She walked at exactly the pace she always walked. Through the checkpoint she cleared every morning of her professional life and turned left toward the elevator. At the elevator she stopped and looked back, once at the checkpoint, at the 2 officers standing there, at the paralegal who still had her phone out, at Supervisory Deputy Marshal Tillman who had, she now saw, also been filming. She pressed the elevator button. The doors opened. She stepped inside. "Documentation wins," she said quietly, to no one. "It always does." The doors closed. What happened to Terrence Mack in the next 72 hours happened in every direction at once, and none of it was reversible. The paralegal's footage was posted at 9:44 a.m. by the time Judge Carver took the bench at 10:03. 2 minutes late. The first time in 11 years she had been late to open her own courtroom, the clip had been shared by enough people that it was loading slowly. By noon it had been viewed 800,000 times. By that evening, 3,004 million. Mac's trial, the civil rights suit brought by a 24-year-old man named Calvin Reese, who had been stopped, searched, and falsely charged by Mac 2 years earlier while driving home from his shift at a packaging facility, proceeded as scheduled. Judge Carver presided. She did not recuse herself. She was not required to recuse herself. Nothing that had happened in the North Corridor had any bearing on the facts before the court. She knew the law. She knew the case. She had read the file 11 times. She was the calmest person in the room. Mac sat at the defense table in a suit his attorney had chosen and stared at the bench and understood, in a way he had not understood at 9:17 that morning, that the woman reading from the case file was the same woman he had gestured away from a security checkpoint with a sideways sweep of his hand. She did not look at him differently than she looked at anyone else. She did not need to. Calvin Reese sat at the plaintiff's table and watched the judge and tried to understand what he was seeing. His attorney leaned over and said something quietly. Calvin nodded slowly. Gary Felton was placed on administrative leave before lunch. The courthouse security director, a woman named Patricia Hollins, who had been in her role for 9 years and had received the complaints about Mac with her supervisor's endorsements and closed them accordingly, was notified that the chief judge's office would be reviewing all security checkpoint procedures and associated personnel records going back 5 years. She was asked to make herself available. She made herself available. She brought the files herself in a box and set them on a conference table in the chief judge's outer office and left without speaking to anyone. By the following morning, 3 of those records had been flagged for further review. One was Mac's file, with its 2 closed complaints, with the supervisor's language about his being a strong presence at entry points. Language that would look different, much different, when read alongside a video that had been seen by 3.4 million people. One was Felton's file, which contained a complaint from 2021 that described strikingly similar language at the same checkpoint. The third was a complaint that had been filed, ignored, and eventually withdrawn by a court interpreter named Delphine, who no longer worked in that building and had left, according to her exit interview, because she no longer felt the environment was one where concerns were taken seriously. Delphine was contacted by the chief judge's office on a Wednesday. She had moved 2 hours away and was working as a paralegal in a county clerk's office. She was asked if she would be willing to speak. She said yes without hesitation. She spoke for 45 minutes. She named dates. She named specific language. She had kept her own notes, written the same day each incident occurred, in a notebook she still had in a desk drawer. A transcript of that conversation is now part of a formal review being conducted by the Administrative Office of the U.S. Courts. The civil trial of Officer Terrence Mack concluded 12 days after the checkpoint incident. The jury deliberated for 4 hours and 11 minutes. They found in favor of Calvin Reese on all counts. Judge Carver read the verdict without expression and then looked at the jury and thanked them, each word deliberate, for their service and their attention to the evidence. She looked at the gallery, full, standing room only, people in the hallway, and said the court would be in brief recess before addressing post-verdict motions. She did not look at Mac. She did not need to. At the defense table, Mac's attorney placed a hand on his client's arm and said something quiet. Mac was very still. He was looking at the seal on the wall above the bench. He was thinking about the green light on the scanner. He would think about it for a long time. Mac's employment with the courthouse security contractor was terminated the day the verdict was read. His attorney released a statement describing the termination as premature and retaliatory. The statement did not address what had happened on the North Corridor. It did not address Calvin Reese or Delphine or the notebook with the dated notes. It did not address the 38 minutes during which a federal judge had been made to wait in a hallway of her own courthouse. The statement was not widely shared. The firm that employed Mack lost its courthouse security contract 4 weeks later, following a full review of its hiring practices, complaint procedures, and supervisory oversight by the Federal Contracting Office. 3 other employees of the firm were also removed from courthouse assignments, pending further investigation. The review was not announced in advance. It did not need to be. The records were already in the box that Patricia Hollins had carried in and set on the conference table without speaking. 3 weeks after the verdict, Judge Carver was asked to speak at a conference on federal judiciary access and institutional equity. She accepted. She spoke for 22 minutes without notes. She talked about what the law requires, and about what buildings are supposed to mean, and about who gets to walk through which doors and why. Near the end, she paused. "I did not tell Officer Mack who I was," she said. "I presented my credential. I stated my tenure. Those things should have been sufficient. And I want to be honest with you about why I chose not to say more." She looked at the audience. "Because the woman behind me in that line, the clerk, the paralegal, the interpreter who no longer works in that building, she doesn't get to say more. She presents her badge, and she hopes the person reading it decides to believe her. I am not willing to accept a system where the outcome of that moment depends on the reader's mood. The law does not require you to prove your humanity twice. It requires the person with the authority to read what is in front of them." She straightened her jacket. "I have been in this building 11 years. I have never once been asked to prove I belonged here by the law or by the institution. I have been asked by individuals who did not look at what was in front of them. That gap between what the institution requires and what individuals choose to do is where most of the injustice in this country lives. Not in the law as written. In the space between what is written and what actually happens in a hallway at 9 in the morning." She sat down. The room was quiet for a moment before the applause began. Deputy Marshal Aaron Tillman was commended by the Chief Judge's office for his documentation of the checkpoint incident. His footage, along with the paralegals and the courthouse's own security camera footage, formed the evidential record of the review. He accepted the commendation briefly and went back to work. He is a careful man. He had always been a careful man. He just made sure that morning to be careful in a direction that mattered. Donna Osai finished the Reese trial, filed a motion for attorney's fees that was granted in full, and was promoted to senior trial attorney the following spring. She kept, in a folder on her desk, a printout of the text that Marcus the paralegal had sent her that morning. "Your Honor is at the North Checkpoint. Mack won't let her through. I have it on my phone." Because she thought it was worth keeping. She thought about it the way you think about the moments that showed you, clearly and without ambiguity, what kind of person you were going to choose to be. Marcus got a raise. Calvin Reese used a portion of his damages award to enroll in a paralegal certification program. He is currently in his 2nd semester. He has not spoken publicly about the trial. He does not have to. The record speaks for him, the way records are supposed to. The photograph of Thurgood Marshall, cut from a magazine, taped to cardboard, framed in a 10-cent frame, still hangs on the wall of a workroom in Birmingham, Alabama. Meredith Carver is 81 years old now. She still watches the news most evenings and calls her daughter on Sundays, and sometimes, when her daughter has had a particularly long week, says the things she said when Vivienne was 8 years old. That's the man who proved that the law can be made to mean what it says. Vivienne Carver is back in her courtroom on Monday morning. She is always back on Monday morning. There are 1,863 cases now, and each one requires someone who has read the file and knows the law and understands exactly what the words in front of her are supposed to mean. She reads everything. She always has. Someone has to. If this story stayed with you, if some part of it felt familiar or necessary, or like something that needed to be said out loud, then share it. Because the hallway at that checkpoint exists in every institution in this country, and the people who should not have to prove themselves twice are not always filmed, not always heard, not always believed. Drop a comment below. Have you ever been asked to prove you belonged somewhere that was already yours? We want to hear from you. Subscribe for more stories about people who held the line, not with anger, but with evidence. Because documentation is not just protection, it is power. And every story you share is proof that someone was watching.